I'm Jim Loughlin, a lawyer here in town. I always like to say thank you for your efforts. What you do is sometimes, almost always, goes unrecognized, and I appreciate what you do. I always try to make mention of it. I'm here on behalf of Christine Peterson, 3 Plymouth Court, and representing some of her objections to the application. I also had the opportunity to work with Attorney Malloy for nearly 20 years. It's always a privilege. This is also the first time I've seen the back of her head, and I want to thank you for that opportunity as well. Before I get started, if I may approach just to distribute some materials that I have as well. The first 3 pages are photographs. The first one is of the neighborhood, a nice cul-de-sac, smaller homes, smaller lots. The second is a photograph of the backyard. You can see the gray tarp is where the temporary shed is. That's in the background. In the foreground on the left-hand side is the temporary shed. There was no permit pulled for the temporary shed, and there was no permit pulled for the permanent shed on the left. There's electricity serving the shed, the permanent shed. We've seen a floodlight. There was no electric permit pulled for that. You can also get appreciation for the depth of the yard. This is taken from my client's property. The addition would extend out as far as the second to last post on the pool deck. That would be the depth of it, and then the width of it would be 26 feet, approaching us who are looking at the photograph. The third page is a photograph of the back of the yard. The addition would run from the left edge of the house 2/3 of the way across. The house is 38 feet. That addition over there to the right isn't included. 38 feet, so 26 is roughly 2/3 of 38, so it would run 2/3 of the way across to the back of the house. And then you'll see that second to last post on the pool deck. And so that's the extent of the yard that will be eaten up by this addition. I propose to you that's very significant. The next page is the application from 2003. If you flip down 2 pages, you'll see the drawing that was submitted in 2003. There's not as much stuff there then as there is now. You'll also note on this sketch from 2003, the front porch is not shown. If you look at the application from 2003, and I'm sorry to have you flip back, no front porch is mentioned. After the sketches are minutes from that meeting, and flipping to the next exhibit is a summary of the permits that are on file in the building department. There are building permits, there are electrical permits, there are mechanical permits, and there are plumbing permits. Up at the top, it's entitled Permits Pulled, and right below that, I list the permits that were not pulled. There was no permit for the permanent shed. There was no permit for the temporary shed. There was no variance requested for the front porch. There was no electrical permit for the light in the shed. Permits that were on file follow this summary. It's some 6 or 7 pages. After that is a section of the Wallingford zoning regulations. The second page is highlighted, that's my underlining, of the definition of a side lot line. And then the page after that is the definition of a side yard. And then finally, the last page is a reduced copy of the survey. Looking at the copy Joan has provided is distant. If you look at this copy, you can see how tight it is back there already with the pool, with the temporary shed that was never applied for, with the permanent shed that was never applied for. Now, smack in the middle, he wants to put a 26 by 25 foot that's going to eat up the balance of the yard. What I'd like to review quickly is the merits of this application suggest the variance should not be granted because there is no hardship. The application is also not complete. After those brief comments, I'll introduce additional brief comments suggesting that the history of the property don't warrant the granting of this variance. There is no hardship on this. If the parents of the Marquezes need a place long-term for long-term care, this is not properly zoned for that. What they should do is they should afford the expense of a Masonic home or an Ashlar Village or a Kensington Village. That's what they should do. This is a tight neighborhood, a quaint neighborhood, but my client bought into this neighborhood hoping that she would be able to retire there in comfort and peace and quiet. She is the same age as the Marquezes' parents. The Marquezes should move elsewhere for their long-term care, but perhaps they can't afford it. Affording something is not grounds for a variance. Financial reasons, financial hardship is not a reason for a variance. Variance can be granted only if it's a hardship due to the land. If the Marquezes need a more expensive house because they need more space for their parents, they're welcome to do that elsewhere in a zone that can hold it. The financial hardship that they're suffering now does not warrant the granting of a variance. I also propose the application is not complete. I understand Attorney Malloy was involved in the process late in the game, so this is not implicating her at all, but rather the requirements of your zoning regulations say that plans for the in-law apartment have to be submitted at the time of the application, and there are no such plans here. So a lot of what I'm saying tonight is based on representations that were made to my client. She is in the audience and available for questions if you have any of her. She was told that there will be ingress and egress from the addition in the area between her house and where the addition will be. My client is advancing senior status. She does not want slamming doors. She does not want cars. She does not want snow plowed in front of her driveway because there's no more room on the street because there's cars parked on the street. She articulated it well in her letter. She should be able to depend on the regulations that were promulgated in 1958 so that she can rest easy to know that when she buys into a neighborhood, those rules will stick. Another reason why on the merits this application should not be granted is this is truly an application for a variance of a rear yard setback. I spoke to Casey this afternoon about it, and we talked about it, but we really didn't come up with a resolution. That's why I included a portion of the zoning regulations. A side yard is a yard that is between the house and the sideline. A sideline, portion of it is included in my materials, is the property line that runs from the street. You'll look at the map that was submitted. The line that they're seeking the variance from does not run from the street. So that is a rear yard. That is a rear line, and there's a 30-foot setback required as opposed to a 20-foot setback. And so this application isn't showing what needs to be shown. Moving on to the history of the property. The Marquezes are hardworking people. They've done very well for themselves. You can tell. It's self-evident. The quality of their home shows that they have the ability to afford certain things, and it's laudable what they've done to their home. But unfortunately, they haven't paid attention to the rules. That doesn't make them bad people, but unfortunately, it suggests that their conduct should not be condoned. You can't approve this application because it will set a bad example for the rest of the town when it comes time to pay attention and follow the rules under the zoning regulations. So you know, and I'm glad that letter was in the file and that it was read, we wrote to the Marquezes before they submitted this application to let them know that we'd be here. This is not a surprise. Expense related to these sort of applications are considerable, and we approached them in advance. If you would look in the materials at the zoning application from 2003, that's right after the photographs. The application looks for a second story above the house and above the garage. There is no mention of a front porch. Attorney Malloy indicated the footprint of the house was not expanded. The drawing from that application in 2003 does not show a front porch. If you look at the building permit from 2004, it in fact does ask for a front porch, even though that variance wasn't applied for. That's the first building permit underneath my summary. It's about halfway into the packet. The permit application is dated July 2004, second story addition, 28 by 38, with a 7-foot by 24-foot porch. Look to the back page, the reduced copy of the survey map. You'll see the front porch. You'll see that it extends the nonconformity. That variance was not asked for. Right after they got the variance application, they submitted their building permit, and unwittingly the building permit was approved, even though that variance had not been applied for. I also ask you to recall that the permanent shed encroaches the side yard. Maybe that's inadvertent, maybe it's not. But it suggests that the Marquezes are trying to put onto their property as much as possible. If they weren't, they would have been more respectful of the boundary between my client's house and their own. There was no electrical permit pulled for the shed. The temporary shed was there. Temporary shed is there. Temporary sheds have different rules for approval under your zoning regulations. If it's permanent, regardless of whether it's made of bubble gum or T111 wood, if it's a permanent shed, there's different rules that apply and need to be applied for under your regulations. And then again, I point your attention to the front porch that was built on, even though it was applied for on a building permit shortly after the last variance had been applied for, and that front porch was not made known to your board. Ms. Peterson is the same age as the Marquez's parents. She's entitled to rely on the zoning regulations. She did not stand up and object to the first round variance because that's not her nature. She'd be speaking on her behalf right now, but it's not her nature to object. But still, she should be able to rely on the regulations as they are written. It's a quaint neighborhood. The Marquez's property is too overbuilt. They've taken too much advantage of the zoning regulations, and they actually haven't adhered to the rules as they should have. So for these reasons, because there is no hardship, and because the history of the property suggests that the variance shouldn't be granted, I ask you deny the application. Thank you.
And open it up to the board for discussion and motions.
I'm making a motion to deny.
I'll second that motion.
Motion to deny, Mr. Wolfer,
Yes to deny.
Mr. Knickerbocker,
Yes to deny.
Mr. Reed,
Yes.
Mr. Rice,
Yes.
and Mr. Burney.
Yes to deny.